Greetings to one and all. You're listening to MMJC podcast. In this edition, we will be discussing about some latest updates with respect to SEBI and also with respect to some judicial pronouncements passed by the courts. So, first update pertains to a circular issued by Securities and Exchange Board of India, that is SEBI. So, in September last year, that is in September 2024, SEBI had issued a circular which had mandated pan freezing mechanism for designated persons under prohibition of insider trading regulations. So before this pan freezing mechanism was made applicable, it was that the trading used to happen inadvertently while the trading window was closed, and it resulted into violation of PIT regulations. Therefore, SEBI came up with these circular for under which PAN was freezed of the designated persons, that is DP, due to which such inadvertent trades were not possible. But however, it was not applicable to the connected persons, and therefore it was not 100% effective. Now, on 21st April 2021, SEBI has come up with one more circular under which this pan freezing mechanism is made applicable to the connected persons also. Due to this, by the virtue of this circular, the PAN of the connected persons of the designated persons will also be freezed for that particular security when the trading window will be closed. Therefore, there will be no leak of UPSI or misuse of UPSI, and also there will be no inadvertent trades during trading window closure. So, this circular is this mechanism of freezing the PAN for connected persons will be applicable in case of first top 500 companies as per market capitalization from the date 1st July 2025, that is after the quarter ending 2000 June 2025, and for all other listed companies it will be applicable for from 1st October 2025, that is on quarter ended September 2025. So this is about the SEBI circular. The next update pertains to an NCLT order, which talks about capital reduction by Section 8 companies. So this will be explained to us by Riddhi, our FEMA expert.
The order was issued by NCLT Chennai on 4th March 2025 in case of LBR Foundation India, which is a registered Section 8 company under the Companies Act. The company had applied to NCLT for approval of scheme of capital reduction. The RD had contended that the company had received FDI, foreign direct investment, to the tune of around 27 crores, which was received in tranches from period of 2011 to 2015. The shares allotted by the company are classified as foreign contribution. However, the company had not received registration under FCRA. Company later received registration in 2016. However, since the funds were received by the company prior to obtaining registration under FCRA, that was contended as contravention under the FCRA. RD also highlighted other contraventions, including administrative expenses beyond the prescribed limits and allotment by the company made beyond 60 days prescribed. Petitioner in its defense had submitted that a scheme of capital reduction was already approved in their case in 2021. While remitting the funds as per the scheme of capital reduction, the authorized dealer bank had asked them to obtain valuation report and remit such funds only as per the valuation report required under FEMA. Hence, the company could remit only the funds only to a tune of around 3 crores at that point in time. Further, it contended that since there is no restriction for Section 8 company in case of capital reduction should be allowed. It also mentioned that it had obtained registration later in 2016. However, since the funds received by the company had been lying with the company and there was no possible utilization of such funds being possible, and also the registration under FCRA had expired, it should be allowed to remit back the funds to its parent company. considering the submissions made by both the RD and the petitioner, the tribunal had formed a view that receiving foreign contribution without registration or prior approval was violation under FCRA. Section 7 of FCRA restricts any transfer of foreign contribution. Under Section 8 of Companies Act, any income or profit must strictly go towards promoting the company's charitable objects. Contribution of profits or assets, even in case of winding up, must comply with statutory requirements. Transferring of assets to another Section 8 company, the tribunal was clear, allowing capital reduction in such cases could open the door to potential misuse of charitable funds. And there we have it, the dismissal of LBR Foundation India's petition for capital reduction. This case highlights the importance of complying with FCRA regulations, especially when dealing with foreign contributions. It also reinforces the principle that Section 8 companies must use the resources transparently and only as per purpose for which they were intended. NCLT had held that it would not be just and proper to permit the capital reduction and thereby dismiss the petition.
Thank you, Riddhi, for such elaborate discussion. So now the next order is issued by the Honorable Supreme Court of India. In this case, the complaint was filed under Section 138 and 141 of the Negotiable Instruments Act, that is NI Act, against the non-executive directors of the company. Basically, it was a check bounce case, and the non-executive directors said that since they were not involved in the day-to-day activities of the company, they were not responsible for the check bounce, and hence complaint should not be lodged against them. The complainant alleged that since the non-executive directors were present in the board meetings, they were involved in the day-to-day business activities, and hence they should also be held liable. The Supreme Court, after considering all the relevant documents and arguments, held that mere attendance of board meetings by non-executive directors does not mean that they are involved in the day-to-day activities of the company, and hence declared that the complaint against non-executive directors should be quashed. The Supreme Court in this case highlighted that for vicarious liability against the non-executive directors, there has to be a specific allegation against them, and in absence of such specific allegations, such vicarious liability cannot be enforced. So that is all in this edition of MMJC updates. Please feel free to write to us about your feedback. Thank you.